At this point, we all know who Diddy is, right? You know, he has a huge empire until that came crashing down, and now he's in jail charged with sex trafficking, among other things. By the way, which he pleaded not guilty to. But he's been slapped with a number of lawsuits accusing him of sexual misconduct, including rape and assault, which he also denies those allegations too. So here we are, around 40 lawsuits deep, a trial that's right around the corner. But one thing maybe Diddy didn't expect was the largest department store in the US calling him an equal opportunity predator. Yup, those exact words. So let me explain. Back in October, a client of Tony Busby filed a lawsuit against Diddy accusing him of orally raping him in a Macy stockroom. Now, this alleged attack happened back in 2008. John Doe says at the time he was working for Echo, the rival clothing company to Diddy's Sean John brand. Both of those clothing lines were carried at Macy's. On the day this allegedly happened, John Doe says Diddy entered the stockroom with bodyguards, who were armed by the way. Doe claims one or more of the guards hit him, or he might have been pistol whipped, which caused him to fall to his hands and knees. Now, Doe says one or more of Diddy's bodyguards threatened to kill him, but then Diddy demanded he perform oral sex on him. The plaintiff described in his lawsuit the oral rape went on for about 2 minutes. And after the attack, Diddy grabbed a bunch of Sean John merchandise from the stockroom and began passing it around to a crowd as if nothing happened. So beyond this allegedly happening in Macy's, what does this have to do with the department store? Well, they're named in the lawsuit as a defendant. According to John Doe, 3 weeks later, the CEO of Macy's pressured Echo executives to fire John Doe because he signed a multi-million-dollar deal with Sean John Clothing. Now, John Doe also believes the assault was destroyed or purged from Macy's records and no action was ever taken. So that was laid out in the lawsuit filed in October. Now, jumping to this week, the retail store is asking a judge to remove them as a defendant in the lawsuit. Now, here's their reasoning. They claim the 2022 amendment of New York City's Victim of Gender-Motivated Violence law doesn't apply and didn't extend to corporations. But the department store also argues John Doe fails to plausibly allege he was a victim of gender-motivated violence and that he contradicted his claim. In their response, Macy's writes, plaintiff's own allegations established not only that this was a same-sex assault, but that Mr. Combs sexually assaulted both men and women without regard to gender. Macy's lawyers continued by writing, other than saying in passing that it does not matter, plaintiff does not address the fact that his own allegations established that Mr. Combs was an equal opportunity sexual predator. So essentially they argue Diddy doesn't care about gender. But they point that going off John Doe's claims, Diddy might have been motivated by race instead. Why? Because Diddy allegedly called this John Doe white boy when he attacked him in the stockroom. Now, Macy's lawyers wrote, in light of the racial context of the phrase as a whole, the use of the boy here functions primarily as a term of status and belittlement, boy versus man, rather than as a gendered comment, boy versus girl. It is in fact an inversion of the classically racist use of the term boy to degrade or belittle African Americans, end quote. So yeah, Macy's definitely had some interesting arguments to not only get them removed as a defendant, but get the complaint dismissed entirely. But will it work? According to Tony Busby, it shouldn't. Now remember, he's the Texas powerhouse attorney filing dozens of lawsuits for more of Diddy's alleged victims. He responded to this argument by telling Business Insider a pretty novel argument that should fail. Well, Diddy's attorney responded too with a motion to dismiss the complaint, but also for the plaintiff, aka John Doe, to reveal himself. It's unclear right now how this will all fare out. No court date is set in this particular case. But Diddy has a lot more to worry about, like his federal trial set in May. Let's bring on now criminal defense attorney Oleg Nekritten to break down this fiery response from Macy's. Oleg, thank you so much for joining me. What's your reaction to, because let's go back a little bit, back to October. What's your reaction to Macy's even being named in John Doe's lawsuit after they were accused of covering up the sexual attack?
It's surprising because if you read the body of the complaint doesn't actually allege that the individual who was victimized was an employee at Macy's. Instead, it alleges that he was in a Macy's store. He was in the back room, maybe the stock room, working as a consultant for Echo. Not sure why he'd be in the back room, but he was. And he alleges that P. Diddy, Sean Combs, comes to the back room with 3 bodyguards. One of the bodyguards apparently hits him on the side of the neck, causes him to go down on his knees, and then, unfortunately, Mr. Combs allegedly forces him to have oral sex. Um, he doesn't actually allege that Macy's did anything prior to the event, the purported unlawful event, to cause any wrongdoing or any sexual assault or cause him to experience any wrongs. It's after the fact, meaning after the alleged event, John Doe goes to Macy Security and advises them of the incident. And he alleges that Macy Security essentially covers up the act. That if they take a report, they don't save it, and subsequently he even alleges that the CEO of Macy's actually went to his boss at Echo and forced them or convinced them to fire him after being employed by Echo for 7 years. So it's an after the fact type of conspiracy. Uh, it's more of an allegation of a cover up than actually doing something to harm him. Which, if you read the statute of cited in a complaint under the Victims of Gender Motivated Violence Protection Law or Act, uh, the law applies to individuals or entities who commit, direct, enable, participate, or conspire in the commission of the crime. Here, again, it was after the fact. So it's surprising from a legal perspective that the complaint would be filed, but Mr. Busby is a very successful attorney. He's made a lot of money. He sees a defendant with deep pockets, and like any good attorney, he goes after that defendant with good deep pockets. What's the worst that could happen? The judge will dismiss the complaint, and that's it. So, the plaintiff's attorney sees his shot, and he takes his shot.
And why do you think Macy's didn't respond earlier with a motion to dismiss? Why do you think that they waited until February?
So if you look at the docket sheet, after the complaint was filed in October 2024, Macy's was actually served about a month prior to filing their response. So they actually responded in a timely manner. There was some delay between the filing of the complaint and actual service. So there was no delay on Macy's part.
And, going into Macy's response, what is your reaction to Macy's responding by calling Diddy an equal opportunity predator, given that John Doe filed the lawsuit under the New York City Gender Motivated Violence Act or law? But John Doe also admits that Diddy is willing to attack both men and women in his complaints.
It was surprising. Usually, when you're a defendant, you live by the axiom of don't harm the other defendant, because if your motion to dismiss is denied, you're going to have to work with the other defendant. And you try not to put them in a position where they're adversarial to your interests. But Macy's has taken a calculated risk that the allegations aren't enough to establish a cause of action under the statute pled. The plaintiff has to show under this cause of action that the event or the crime was motivated by gender in some way. If you read the complaint, it doesn't really go into allegations related to animus by P. Diddy towards other men. It doesn't really it doesn't really suggest on its face that P. Diddy committed an act motivated by animus towards man. And that's where you get the quote, he's an equal opportunity offender. He allegedly assaults males and females. And on its face, it suggests that there was no motivation based on gender. He assaults people irrespective of gender. But for a motion like this, a 12B6 motion, where the court has to grant inferences in favor of the non-moving party, which is the plaintiff in this matter, the court could very easily conclude, based on the complaint, that after the incident occurred, P. Diddy was taunting the victim. So the court may simply state that based on the taunting, the taunting could have been motivated by animus towards gender. The court may ask the plaintiff to specify what the taunts were, and then the plaintiff may supplement the complaint or amend the complaint to include details of the taunts. For example, were there derogatory comments towards the individual based on his sex? Did they imply that he was gay or homosexual? And if that occurred, they would probably survive the motion to dismiss on that basis.
And I was going to ask as well too, given what we know now, given that response, do you see a judge dismissing Macy's as a defendant or even the complaint altogether?
I the judge, I think, if he reads the complaint and applies the law in a very measured way, not expanding it, just applies the law in the way that it's written, the complaint will probably be dismissed because the wrongdoing alleged as against Macy's is after the fact, is after the commission of the crime, not before. So the allegation is that Macy's, after the fact, essentially covered the case up, but that that's not assisting in the commission of a crime unless you interpret commission of a crime in a very liberal or vast way. And so some a judge may, but again, if the statute is interpreted in a very conservative or as written way, uh, Macy's will probably prevail on the motion to dismiss, I think, because again, the wrongdoing alleged as against Macy's is after the fact. Mr. Busby, he kind of, in his complaint, in his response to the motion to dismiss, he says, well, P. Diddy had a reputation before this incident, and nobody should have permitted P. Diddy in a Macy's store by himself. And therefore, just the fact that they permitted him in the store, they have potentially acted in a negligent manner. But that's that's probably far fetched. I don't think a court will accept that type of argument.
Yeah, I kind of agree with you there, especially given that these allegations stem from 2008. Maybe it'd be different if we were talking about 2025. Maybe that might be a little more plausible, but back in 2008, would be interested to see if that actually would work. And speaking of
Right.
Tony Busby, he also responded to Macy's response and called it a pretty novel argument that should fail. What do you make of that statement?
It was a pretty clever, unique argument made by the defendant in that they're interpreting the statute from the date that it was enacted, and therefore, for example, before 2022, the statute applied to individuals. After 2022, the statute applies to entities and individuals. But the plaintiff is essentially arguing, I'm sorry, the defendant, Macy's, is essentially arguing that the section of the statute which refers to the grace period, the 2 year grace period from 2022, it applies for causes of actions that arose after the date of the statute. But if you actually read the statute, I think if you interpret it as in a way that it's written, it applies to any and all causes of action that arose before that date, and then you have 2 years and 6 months from the date of the enactment of the statute to file your cause of action. So, I don't think that's the winning argument on behalf of Macy's. I think the winning argument is the statute doesn't apply to the case because whatever Macy's did that was wrong occurred after the fact, after the crime, not before.
And given that, Diddy faces a number of civil complaints for sexual misconduct, given that he's in jail for federal sex trafficking, do you see these complaints getting litigated at any point or these lawsuits getting litigated at any point? And going off of your point that you had just made too, do you see other corporations or entities using that same tactic Macy's did to kind of be like, okay, we kind of still fall under this like weird little period of that the Gender Motivated Violence and Protection Act. Do you see other entities using that same kind of defense in their argument?
Yeah. The problem with filing a lawsuit against P. Diddy is that you got to get in line. There's been many causes of action. I think there's been 30 complaints filed against him. His attorneys are probably going to move for motions to stay um, the cases until the resolution of the criminal matter. Um, there's natural requests for discovery extensions due to just the sheer number of cases and the volume of cases. If you're a defendant that's a company or a corporation, you probably want to drag your feet because plaintiffs, if they don't see the money bag towards the end of the case, they may lose interest and settle for pennies on the dollar, or they just may lose interest and agree to walk away from the case.
Yeah, I guess we'll see where all of this goes. Oleg, thank you so much for your insight into this. I really appreciate your time today. Before we sign you off, though, is there anything else you would like to add?
Nope, thank you so much for having me here. My pleasure.
Thank you again, Oleg. I always appreciate it.
You too. Bye-bye.
And again, Diddy has denied all the allegations made against him. His trial is in just a few short months, set to begin in May. Reporting for Law and Crime, I'm Elizabeth Millner.